You're welcome back. This is Newsfile. It's your most authoritative news analysis show. And here on Newsfile, we put Ghana first. Now, on the back of the recommendations and the submissions that have been made by Mrs. Charlotte Osei, yes, Roxanne, I don't know. When the NDC immediately, without benefit of the reasons, goes into a press conference and charges its supporters to, pour onto the streets the next day and to do a demonstration, how do you get to advise that kind of position?
Thank you very much, Samson, for the opportunity. Let me say hello to my constituents in South Dain,
right?
In Peki, Kwali, Peve, Tongo. Good afternoon. Sam, we do so as a party because, you see, this whole exercise appears, and legitimately so, to have fed into a certain agenda. Yes, my sister and senior attempted to debunk that we shouldn't read partisan meaning into it. We should look at the whole exercise and the generality of the interests of the people that has been safeguarded. But we'll side with her, we'll agree with her if statements had not been made in the past to this effect. And I don't know whether I should repeat those statements and even mention names of persons who made those categorical statements.
What statements are you referring to?
I refer particularly to statements to the effect that as soon as we regain power, we'll remove Charlotte by any means necessary.
Who said that?
And Kennedy Ejapon said so. Oh, please.
Does he speak for the MPP in this matter?
Why? You see, when we make the statements like that, he doesn't speak for the MPP, and yet he's just a big stakeholder in the MPP, and nobody debunked this. And 18 months down the line, what it said, or the promise that he made to his party people, has been effected. Sam, I want to leave the generals and move to the specifics.
Okay.
We are told that 3 petitions emanated from some persons and were sent to the office of the president. And with the dispatch, they were referred to the appropriate quarter as the Constitution.
2 or 3?
3. 3 petitions. 3 petitions.
Actually 2.
No, 3 petitions.
Which one? Oh, what are we talking about?
You see, 3 petitions. You see, yes, we are told that 3 petitions. One was in respect of the chairperson.
Mm-hmm. Yes.
All right?
Yeah.
Then 2 others were in respect of the 2 deputies.
Yes.
Okay,
right.
you normally consider those as one, really.
Well, came from one person.
Well, okay. Now, the CJ hasn't told us which of these petitions her committee worked on, or which of these petitions... Hold on. We are yet to be told.
I can't really follow your drift.
Okay, my drift is this. 2 different petitions or 3 different petitions have been submitted from the office of the president for a consideration, because one was in respect of the removal of the EC chair.
Yeah.
The others were in respect of the removal of her deputies, 2 deputies.
Correct.
Okay.
Right.
Now, in making a prima facie determination, so that the petition, as she's received them, is referred to a committee she will establish, she has to tell us that out of the 2 petitions, or let me say 2, that I have received, I have made a prima facie determination in respect of 1, which is in respect of the one seeking for the...
Can I assist in this regard? Sure. The letter that conveyed the recommendations to the president,
yes,
for him to exercise his obligation in Article 1469. This is what it said. In the matter of the investigation of 1, a petition for the removal of Mrs. Charlotte Osei from office as chairperson of the Electoral Commission of Ghana. 2, a petition by Emmanuel Kosi Senyo for the removal of Mr. Amadou Sule from office as Deputy Chairperson of the Electoral Commission of Ghana. 3. A petition by Emmanuel Kosisenyo for the removal of Ms. Georgina Opoku Amankwa from office as Deputy Chairperson of the Electoral Commission of Ghana, and in the matter of the recommendations of the Investigative Committee.
Yeah.
Okay. I hope that settles it.
Yes.
Okay. Yeah.
No, but my question is still this, legally speaking. So is she saying that she consolidated the petitions, these 3 separate petitions, and made a prima facie determination in respect of all of them as consolidated?
4 for Sule, 4
for... Hold on, Kweku.
Yeah.
You see, or she made a prima facie determination in respect of each, after which she consolidated and referred it to a single committee. These are, you see, I speak with a legal mind. We are sifting the procedure.
We are all lawyers.
Yes.
So we understand.
Yes. No, I am doing the explanation so clearly that you understand the procedure that has been applied.
Okay.
Now, under 146.4, which is very clear as to when the petition is referred to her, the exercise she is supposed to conduct as to the determination of the prima facie case, it's a quasi-judicial one. So, we have also not been told from the report, the excerpts that I have seen, the burden of proof or the standard of proof that she adopted in determining, because you see, in determining a case of a prima facie, it is on the face of the petition that you do so. You don't invite...
Are you asking for the record of her prima facie determination? Because
yes,
we
because
know,
I don't have
we know that there was record of her prima facie determination.
Yes, there was.
Yes.
I have a copy.
And I'm saying that I don't have that report.
Yes, so there is.
There is.
So you may want to proceed there.
Yes. So I am saying that I need to know the burden of proof that she adopted in evaluating the petitions on the face of it. Now, once that is that, because it's a judicial process, you have to do so given the judicially determined standards that the Supreme Court has stated.
When you read the recommendations,
yes,
you will find excerpts
exactly
of what she had to say to form the basis for the determination that, for example, in respect of Charlotte Osei, the 6 were the main issues to be determined. And then in respect of all the others, it were 4 issues each.
Sam, by making her prima facie determination, she whittled down the issues from the convoluted 27
Not
or 20.
whittled.
She
rejected some
you see,
and adopted some.
It's diction. You know, it's like the way the court will say, the parties filed the issues, but after the trial, the court has set the issues down to maybe 2.
That's okay. Please proceed.
All right. She decided to whittle the issues down to 6 grounds and referred it to the committee. Now we are talking about persons who are the subjects of this inquiry, and they are non-judicial persons. So I'll refer to Article 296, where the exercise of her powers in this matter is discretionary. Now, 296 is very clear. Where in this constitution or in any other law, discretionary power is vested in any person or authority, C says, where the person or authority is not a judge or other judicial officer, they shall be published by a constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this constitution or that other law to govern the exercise of the discretionary power.
Where it is not, the person is not a judge.
Yes. And the persons who are subject of the inquiry that had just been conducted were not juristic officers. So, for instance, I was expecting that she would have crafted a constitutional instrument to state the regulations.
No, we have just read the constitution,
yes,
which says if you are a judge making that determination, you don't need an instrument.
You see,
It is when you are not a judge that you require an instrument.
You see, in exercising this power, the CJ sits in a composite capacity. She exercises this as the administrative head.
She is the Chief Justice.
Yes, but you know that she sits in a composite capacity.
So what's the argument? There's precedent. There's precedent. We have moved on from that point.
It's immaterial, Sam. The fact that there's precedent and it's procedurally wrong doesn't mean we shouldn't do the right thing. Yes. So that when the person is aggrieved, the person must know that these were the procedures that were followed. CJ didn't craft a constitutional instrument.
This is a committee, right?
Yes, a committee of inquiry.
Yes, and you know that commissions of inquiry. We have a commission of inquiry instrument.
Yes.
We have a CI.
Yes.
That regulates how they conduct their business. So that's what you apply, or what else are you looking for?
Was it applied in
inquiry?
No.
This is the same.
This is a committee of inquiry.
No, the Supreme Court said in Dr. Opong that it is the same. It is the reason if you have to appeal, your right of appeal is to the Court of Appeal and not the Supreme Court.
Interesting.
Okay.
Committees of inquiry are the same because their findings are deemed as, decisions of the High Court.
Okay. So in this special procedure, are you saying that the CJ didn't need to craft a special constitutional instrument to undertake this?
The law says if you are a judge, you don't need it.
And she's a judge.
Yes, she's a judge, but she's sitting in a composite capacity. She's the administrative head of the judiciary.
Okay.
This is an administrative procedure.
So can we proceed to another?
Yes.
So this may be a bit more difficult for people to understand who are non-lawyers.
So I am saying that every
legal point.
Yeah, procedurally,
maybe lost
I have issues with it.
Okay.
Yes, which when a party is aggrieved, there are some of the issues they could raise.
But they didn't raise this. It wasn't one of the points they used to fault the process.
Now, but if I am aggrieved by the these findings, which I find very, very crafted to feed into a certain agenda, even the choice of words, you see that they looked
agenda.
Yes, they looked out for the two stated grounds in the provision, in the constitutional provision, stated misbehavior or incompetence.
And the third one.
So every.
What is the third one?
Okay, either
for
or.
this, no. It's important for
it's
the education of the public.
Ill health arising from inability to perform your functions arising from ill health.
We know that. No. We speak. Hold on. We speak in context. We speak in context.
Okay.
That ill health angle is not featuring in this matter.
That's right.
So you see that they chose these two words: misbehavior, incompetence. So every other phrase was crafted in such a way to emphasize or harp on the word misbehavior.
Are you saying that if you did not object to the process,
yes,
on a certain point,
yes,
you can go on appeal on that point, which you did not object to? You succumbed to the process, you went through it, you didn't raise it. Now, if you look at the respondents,
yes,
they had a number of objections,
yes,
maybe put into 3 broad categories.
Yes. Preliminary legal objection.
That's the nature and form of the petition itself,
yes,
the non-signing of it,
exactly,
and other matters, and then they come to the premature nature.
The fact that there was even fraud being perpetrated.
They come to the premature nature.
Yes.
That it is premature on a number of grounds, including that by the Procurement Act, you should have exhausted the Procurement Act process.
Internal remedy.
And also that it was brought in bad faith, because these people had already orchestrated, they wanted to do this before they brought it.
Yes.
So they can go on a number of grounds on appeal, but not on the point you are raising now.
No, you see, I am saying that you can be fault the procedure.
Okay.
It's part of the grounds that wrongful procedure was adopted. You understand my point?
You didn't question that wrongful procedure when you started?
If it's legal, you can raise it at any time.
Okay.
A legal point can be raised at any time.
Okay.
So the point is this: if I were Charlotte and I am aggrieved by the contents of this report, based on which I am being dismissed, I have to proceed to court.
Okay.
And if I'm proceeding to court, these are some of the issues I raised.
All right.
That is my point. And 2, Sam, we are talking of the whole inquiry's findings was based on procurement breaches, which for me
against Charlotte
are mere breaches. Because you see, there are doctrine in our contract laws, in our commercial laws that says that where acts which are not fatal can be rectified, there's ratification. Okay, you can go back and correct as if the act was done from the beginning correctly. So these are doctrines.
Even after the contract has been consummated, it's finished, it's gone, you can still go and correct.
Indeed. That is why there are penal sanctions. So if you think that you can't rectify that act, what you do is that you bring the person under the penal sanctions.
So that they pay fines or something.
Exactly.
Like that. Including the prison terms.
5 years.
Oh, that is all?
Because it's fines.
Hold on.
Fines or prison term of 5 years.
You understand? So
you would have preferred that?
No. Yes, I would have preferred that.
Okay.
That given the nature of the breach, would it be... No, would it be proper for you to imprison the person? Or you can reprimand like they are recommending. They've written a long thesis of recommendations. The committee could have done that.
Okay.
That upon the inquiry, given the high sensitive nature of your office, we will want to reprimand you and recommend that the following are strictly done. That is the way you safeguard the sanctity of high offices.
Okay.
But you see, we are treating this office as if it's the office of if I give the example, I mean, like a lowly placed office within the public sector.
Personalizing it?
Yes.
Depending on who or which office it is.
I am not personalizing. No. I am not saying, I'm not personalizing.
Subjective application of the law?
Not at all.
Not
at all. As we speak, EC is still collecting money, cash, from political party for political party operations.
That's what I'm
they haven't stopped.
You just going to give them cash. Yes. You give them 5 million in cash. 5 million.
No 5 million. No 5 million.
That's what it says.
But every
5 million in cash.
But every for instance in the Volta region, I think every constituency paid, and we paid before EC supervised the elections for us. But that's the point, that even though this one is a matter of inquiry, they are still undertaking that exercise. So you don't really remove the head because of such a breach. All right? You can recommend institutional reforms, but you don't have to remove the head, because we think that it is because of a certain agenda to get there out. Now, the other issue is also this, that if you look at the burden of proof, like I said, the committee itself, I didn't find it anywhere in the report.
You don't have the full report,
though.
Okay, I have excerpts.
You have excerpts, yes.
Okay, but the excerpts, I should be able to see that in analyzing the evidence adduced before them, they applied a certain standard. Is it on the balance of probability standard, or on the preponderance of probabilities, or on the proof beyond reasonable doubt? We need to know, because the standards are not the same.
What standard do you think they should have used?
This is
the civil standard.
This
or
is
the
an administrative
standard?
process. All right, this is an administrative process. But in construing the PPA law, which makes a penal provision for breaches, then the standard should have been one of beyond reasonable doubt, because there's a penal application.
And is it your contention that there was any matter that they were found guilty of, quote unquote, that the petitioners did not prove beyond doubt?
I
think so.
You think so?
I think so. Because you see, if it was on the balance of probabilities,
the US aid funding,
yes,
for the project,
yes,
the contract between, or the agreement,
yes,
between the EC and the
UNDP
and the US aid,
yes,
says that you should use your own local procurement
in accordance with your
own local procurement laws.
Yes,
they did not do that. The evidence shows that they did not do. What are you saying? Are you saying
not in totality?
That is not proved beyond doubt?
In totality. The report itself says that on occasions they complied. No, it said so. For instance,
some of them to a certain extent.
Exactly. So you look at all that conduct. Did the person willfully fail to comply, or in the course of the work, there were variations which they forgot or they failed to go back for consent or for permit to be able to do that. Because if it's on the preponderance of probabilities, you are going to look at conduct as a certain culture fed into the practice. If it is, then of course you can waive it.
You can excuse it.
Exactly. But
it's a question I'm asking you.
Yes, I agree. No, you are asking me a question. I'm saying that's the point I'm making. So we need to know which standard, which burden of proof standard did they adopt in placing the probative value on the evidence.
Okay, so this morning you're asking a whole lot of questions. Just hold on briefly now.
Yes, because we are analyzing the report.
Yes, let me come to
because it's become a legal document.
Doc, if you could, because we will after your first point, we will come to look at, matters that will suggest to look at the recommendations, so to speak. Okay. But about the future of the EC moving from this point. About the future of the EC moving from this point. He does seem to suggest that, if you like, part of the reasons that were raised or the arguments that were canvassed by the Electoral Commission as a respondent were that these are procurement breaches. If they are procurement breaches, the PPA or the law allows the PPA to exercise that power to do an investigation and establish what may have gone wrong. And when they finish all of that, according to the Act, Section 90, you will find that it says that after they have done that, the board shall, if satisfied that there has been a contravention of a provision of this Act or any other enactment in relation to procurement proceedings or procurement contracts, take action to rectify the contravention, which actions shall include A, annulment of the procurement proceedings, cancellation of the procurement contract, rectification of anything done in relation to the proceedings, or a declaration consistent with the relevant provisions of the Act. Do you think that this, what he's suggesting, it is valid? That is what could have been done, looking at particularly the high office of the chairperson and the deputies?
Thank you very much. You see, I think when it comes to the issue of Electoral Commission, a number of issues have been raised. One, the corporate governance issue. We are where we are here because of breakdown of corporate governance. I've always said time and again that when you have a commission and then you have people who go to sit as chair or members of the commission taking a decision and then come back to implement, it creates a conflict of interest situation. And that is what has brought us where we are today. Let's come to the procurement issues. And let me also make reference to a statement or a word that has been used throughout the report: incompetence. Incompetence. It is not so to call that to say that they lack the competence to become electoral commissioners or commissioners, but I think they lack the competence in administrative practices and management of the public financial management system. Because the issues that were raised in the report were not issues that I think, if their capacity had been built in those areas, I mean, they couldn't have avoided. They would have found wanting. Let's come to the Public Procurement Act. It is true, when you look at Section 90, Section 89, an investigation by the board, but this investigation will have to be premised by the Public Procurement Authority itself, But in this instance, and even when you look at 91, it is the duty of the Public Procurement Authority to annually undertake statutory audits, procurement audits of all state institutions, including Electoral Commission. Question then is, were they doing these annual statutory audits? And if they were doing it, how come we are where we are?
So are they right, as the respondent, to suggest that this action was premature? Wait for some of these processes to be consummated, and then if there are adverse findings by the procurement PPA, then you can use them for whatever purposes.
I think they are not right.
They are not right?
They are not right. Okay. I think for them to sit down, to allow a committee to uncover this and then indicate the procurement breaches before coming up to use that as a defense is not correct in public financial management. I think it's good. We should look at the administrative bit, and then we should also look at the procurement breaches.
No, a small point. It was a petition that alleged
Yes.
At that time, at the time they were raising the preliminary legal objection. That it was premature.
Okay.
It was the petitioners who were alleging. So they were saying, no, you don't have to do this. Wait for the board to raise the issue. So it was the inquiry that later maybe established the allegations.
So the wrongdoing.
So the wrongdoing. At that stage, we cannot truncate the process. No. The process couldn't have been truncated. We should allow the process to go the long haul. Then after that, a report will be submitted. In my respective view, I think that this report does not even prevent the PPE from coming in to conduct a statutory audit under Section 91 of the Public Procurement Act.
You are saying that the PPA can come in and now make contrary findings.
Not necessarily contrary
to what the committee has
done. They can look at
writing on the independent findings.
Writing on the issue, or they can come in under their statutory authority under Section 91 of the Act and say that, okay, we are coming in to do the statutory audits. And then when they come out with the statutory
audit, make this whole thing untidy and a good reason, a sound reason why you ought to follow step by step. Exhaust one position before you move, you escalate.
That's the more reason why we are exhausting the procedures and that
when you trigger one position,
you need to exhaust. Yes, you need to exhaust it. So Samson, I think we have exhausted it. They are going into implementation, and the president's duty is to implement the recommendations. But there are issues, Samson. You see, it brings into question how we engage these public officers, heads of constitutional institutions or bodies. You see,
and other statutory bodies.
Other statutory bodies. Is it about time we open it up to competition? Is it about time we publish it? Because we have people who can perform. This is not to say that those who are being removed cannot perform, but can we open it up? Can we tighten the corporate governance practices of these institutions? Can we encourage or can we support them with administrative reviews and administrative measures so they will be able to comply effectively with the public financial management system? I see this as completely, they are either lack of understanding or knowledge in public financial management systems. And then I also see it to be a breakdown completely of the internal control systems within the organization. Because under the public financial management system of Ghana, you should have an internal audit unit that would periodically, every 3 months, undertake an internal audit, including a review of your procurement systems and submit findings for systemic improvement.
They supposedly do so.
No, it's not as if it's total.
Yes, they do.
Nothing at all. Because if you read
Charlotte actually requested for the internal auditor to look into these processes before
the findings in the report are actually exactly what the internal audit report came out.
And the committee said
the UNDP report, which Afarijan had commissioned.
Right.
All those things are in there.
Which means they've got all these recommendations and have never acted.
I think there were 2 reports.
No, but that report was August 2015.
Let's have Doc continue.
Yes. So in my view, I think it's about we've come to a point where we should purge all these state institutions of these systemic administrative lapses. Kweku raised an issue of personal knowledge of the petitioners and evidence to support it. You see, in my view, I think personal knowledge is good. It brings out the issues. But then the rule of the game is evidence. So in that case, if a petitioner petitions and says that, look, the director of finance or this person will come in to support it with evidence, it is not out of the equation.
But if it became a pattern, it was a pattern. It wasn't like one question, but consistently. For me, that was problematic. If you are a petitioner, for such a serious exercise, you must have some knowledge, some information. I mean, please, otherwise, they said
they have some information, and the committee had enough evidence to support that.
Disappointed.
On the issue of sorry at law, Samson and then seniors, you know that when it comes to the issue of retainer, they give you one single letter that we appoint you as a retainer. Subsequently, if there are cases, you go to court for us, you submit an invoice, they pay you. And I guess that was what happened, unless they are telling us that there was not even a retainer letter to the institution or the chamber, sorry, at law. There would be. If they do not have a retainer letter,
that evidence wasn't before the commission.
That evidence
was also questioned the billing system. And I was shocked that we have a scale of fees at the bar.
You know, so that is also another
Doctor's point is moving on them one by one. So
yes, and then something on the issue of scope of application, donor funds, the fact that the PPA, the Act is not applicable to donor funds, that we have all agreed here, and it is in the amended PPA Act that look, the scope of application is so wide that you cannot say that if you are procuring from donor funds, you will not apply the PPA.
Right.
You know.
All right. So, but it's instructive to read just this portion.
Okay.
On the sorry at law matter you referred to at page 14. They said that of the recommendation, the report, it says that the fact that there were no records on the appointment of the previous solicitors. Kweku said it used to be the situation there. There were no records of the appointment of the previous solicitors. Messrs. Links, Kwashi, Aidan could not be a justification for the manner Messrs. Sorry at Law was appointed. The only records at the Electoral Commission referable to Sorry at Law are letters emanating from the law firm requesting payment for legal fees for services rendered.
So there was no retainer letter.
No retainer letter.
There was no retainer letter. So I think the committee is right in drawing that conclusion. So basically, Sam, what I'm calling for is that
have you found instances where even a corporate entity engages counsel to do a case, and then they take their next case to them, as and when it becomes necessary, and there's no need for a retainer? Haven't you found that? And that is normal practice?
It is normal practice in certain cases.
Because when you do a retainer, you may be required to pay monthly or something.
Definitely. You see, it may be the practice in certain cases, but it is also your duty as a lawyer to formalize the relationship if it continues and it is very consistent.
You know,
no, if the client wishes that as and when I have a case, I'm going to bring it to you, I don't need a retainer.
And
it is right. There's nothing wrong with that.
No, you can never tell when a case is coming.
Yes, particularly it is periodic. It is only when the season is up that the claim.
But when you look at it consistently,
you know, Samson, just a small point. There's another part in the report which says that Madam Upokwa Mankwa indicated that she had once told the late Carla Dongo, who was a lawyer at Sorry at Law, the need for the law firm to regularize their appointment with a contract. These concerns were, however, that was also oral. They were also, however, not documented.
Yeah,
so at least there had been conversations.
That was Mrs. Amankwa talking. And she was seeking refuge in the ghost land.
Yes.
but something you see.
But if you are appointing me, you must give me the draft contract.
No, but you see, your failure to even give them a retainer letter even opens a lot of challenges for the organization. Because every now and then when you have a case, then you are then compelled to use either competitive means to engage a solicitor. You understand it? So if they had gone through the retainer lettership, it would have saved them a lot of
things. In the event that there's a litigation over fees.
I wanted you to answer this.
That's right.
That I do not intend to engage you to be my lawyer permanently. So I don't need to have any retainer with you. I could have a retainer and provide that caveat. That even though we have this retainer, yes, this is what is going to happen.
Okay.
So is it not normal practice, as you know it, having been called to the bar how many years now?
11 years.
11 years now. That it is normal practice
to
say that this is my lawyer, but he's my lawyer only when I have a case I take to.
But some say, you know that it is easy to say that, and lawyers are prepared to do cases for clients. But if the history suggests that consistently, if you have a case, you always use that lawyer, then it's time to reason by convention that you have to formalize the arrangement.
No, but does that constitute wrong?
It's not a crime in my view. But then, you see...
You're supposed to be incompetence and misbehavior in this context. That's what we have been told.
You're supposed to formalize.
All what I'm calling institutional court is a complete overhaul of the institution called electoral commission.
So you don't remove for that to be done.
This is what I'll do. This is what I'll do. We'll take a very quick, which is our last break, and return to look at the future of the EC. The president, Nana Addo Dankwa Akufo-Addo, potentially, or not potentially, actually effectively, will be appointing all 7 members of the commission.
I see.
We'll be right back.
7.
Well, he will explain to us.
There are 4.